It's great to have you join me on the first edition of Law and You. And today we are looking at separations of powers under the 1999 Constitution. You agree with me that there are issues concerning how to deepen democracy. And for us to do that, then we must ensure that the organs of government are in place. And no organ should be seen as exceeding its constitutional powers or rights. We're looking at what Thomas Hobbes did say when he theorized that life is short, nasty and brutish without a government. Life becomes chaotic, and then that brings the reason for us to have a virile government, and that's about the theory of the state, how it came about. But we must also depict the fact that what Baron de Montesquieu propounded from the writings of John Locke, which has to do with the separations of power, the doctrines, and the principles of checks and balances in order to have these organs of government in check, becomes the crux after this discussion. My name is Philip Omo-Gyukpo. I'm your host, and joining me to have this very viral, robust discussion is Al-Amin Alao, a legal practitioner. Thanks for joining me, Alao.
Thank you very much. Good morning and good afternoon, viewers.
Okay, we'll look at this whole issue of rocking the organs of government and the need to have separations of powers, the need for the legislature to carry out its functions in making laws, and then the judiciary interpreting these laws, and then dovetailing to the executive implementing these laws. Now, these theoretically are organs of government that are not having one power over the other. Now, what do you make of these organs under the 1999 Constitution in Nigeria?
Thank you very much. Like you have rightly mentioned in the course of your introduction, the doctrine of separation of powers actually can be traced back to the 17th century.
Okay.
Mentioned the name Locke, and of course Montesquieu, the French philosopher, who both felt that in order to avoid tyranny, we should not have powers concentrated on a particular body. Powers should be separated so that one body can act as check and balance the other. And of course, the 1999 Constitution fulfilled the conditionalities of separation of powers. The 1999 Constitution fulfilled that. If you look at it, you have Section 4 talking of the legislative powers. Then you have Section 5 talking of the executive powers, and then Section 6 judicial powers. The legislative power is so important. It starts governance, because without law, who will rule? How do you rule? So that explains why the Constitution placed first the legislature. And of course, we have the National Assembly at the federal level, and of course, you have the House of Assembly at the state level. We are talking of the Senate and the House of Reps. Then National Assembly at the state level. Now, they are to make the laws. If you now make the law, you are not to execute the law. You are the lawmakers, you have made the law. How do we appoint the president? How do we appoint the governors? How do we appoint the local government chairman? You made the laws. How do we do this? Everything has to be documented. And that is work of the legislature. Now, having been done, you now have the executive coming in to now execute and implement. And of course, the executive that comes in to execute and implement cannot go ahead and interpret. That is reserved for the judiciary. Judiciary is to interpret. But if you look at it, you cannot now say that separation of powers, yes. But at the same time, in modern government, it requires that the three arms of government should actually work together. They shouldn't be confrontational, but it should be mutual understanding and cooperation among the three arms of government in order for government to actually function properly. Otherwise, you observe that, okay, you observe legislature trying to always make laws that will be difficult for the executive to implement. Let's deal with them. Or the judiciary want to interpret, okay, your matter is before me, I know what to do. So there should be cooperation. And so you cannot completely now separate them. And that now calls for the doctrine of checks and balances. Checks and balances now come in. Now, you will observe that the president appoints the chief judge of the Federation. The Chief Justice of the Federation, appointed by the President, you now discover that he cannot just appoint Somoto. That appointment has to be confirmed by the Senate. You can see the three arms coming together now.
Yeah.
You want to appoint the Chief Justice of Nigeria, CJN. Appointment is done by the President. The President says, oh, I like Philip, I want to go for. But it's not just like that. Then the Senate has to say, who have you appointed? We need to confirm that appointment. If it's not confirmed, of course, you are knocked out. It's not enough for you to lobby with the President and say, I'm qualified. And then you are appointed. So you can see the working together of the three arms of government. And then if we go further, we discover that at the state level, when the governor also appoints the commissioners, it's not automatic. You go to the House of Assembly, and then the commissioners, the House of Assembly will now have to also confirm those people who have been nominated by the governor.
Okay.
They have to confirm.
Okay. Thank you very much for giving us that very, very exhaustive and total content, what it pertains to separation of power and the principles of checks and balances. But let's look at what you said about the 1999 Constitution, that it spelled it out properly.
Yes.
Now, but let's look at the powers, because it is expected that no organ of government should go or exceed its constitutional roles. The executive shouldn't be seen, doubling into the functions of the legislature, just as the legislature shouldn't be seen, carrying out the functions of the executive. So also with the judiciary. Now, there seemed to be the impression being given under the Nigerian 1999 Constitution that it seems to rest more powers in the executive.
Generally, it always appears to be like that. Because you discover that when it even comes to appointments, whether by election, to become the president and the governor appears to be more difficult. To be a president appears to be more difficult than to be a member of the House of Reps.
So you mean it's more competitive?
Senate. More competitive, more demanding. The same thing, the governor of the state. Now, the head is the head. Despite the fact that we are trying to say, okay, separation of powers, checks and balances, there must be a head. And whether you like it or not, the executive remains the head.
So you are saying that the organs of government under the Constitution of the Nigerian 1999 Constitution, yes, they are not equal. Is that what you are talking about?
They cannot be
in terms
equal.
Of the powers.
In terms of practicality, when you are practicalizing now, they cannot expect it to be equal. The Constitution only tries to ensure that there is no tyranny. Let us be able to check the president. For example, the president can be impeached for gross misconduct, even though you have immunity while you are in office. But when you leave office, of course, you can be tried. And at the same time, you can be impeached. Even if the president, if the ministers who are appointed by the president at the particular time feels that, oh, the president is no longer capable, either is no longer sound, health-wise,
yeah,
infirmity of mind or body, then of course, two-thirds majority of the ministers can move a motion that the president is no longer capable.
Well, I think that's on theory, but
yes,
but how practical is it in Nigerian Constitution? Because there seems to be a process, like you said,
yes,
to third majority.
Yes.
Getting that is like an Herculean task.
Ministers will be loyal to the person that appointed them, the president. So you now have the party factors now coming in, loyalty to the president and not to Nigeria. Oh, this president is sick, he can no longer talk. President is okay, everything is well. President is very sick. In fact, others capitalize on that, performing his functions for him. Instead of saying, oh, he knows, or some of the ministers will be aware that if the president is out, we may also lose our seats. So they prefer to keep him there.
They're tied to the apron string.
Yes, let him be there, because he appointed us. And once he's out, we are not sure of retaining our seats. So corruption comes in. There is no deliberate interest to actually take care of the country, but we are interested in our selfish ends. That is one of the factors responsible for that. Now, as I was saying, the president, under the 1960 Constitution, it's covered that we are operating the parliamentary system of government.
Yeah.
Then the powers were shared. You have the president, then you have the prime minister.
Under the parliamentary system.
Under the parliamentary system.
Yes.
Now, so you have the prime minister. But here, now the power is now concentrated
on one
person. That's the president.
Okay. Under the presidential system.
The president is the president, commander-in-chief of the armed forces of the Federal Republic of Nigeria.
Does that not make it a setback under the presidential system we practice?
Yes.
Or will you say it's as a result of the 1999 Constitution?
It is
because some have said that the 1999 Constitution was foisted on us by the military, and so it didn't carry the majority decisions of the people that are being governed, and so there's room for amendment of the Constitution.
If we look
what do you
at
make
it,
of that?
If we look at it, we have already adopted that Constitution indirectly, directly or indirectly. We have already ratified that word. We have already ratified that Constitution. If we believe that, oh, this was imposed on us by the military who sat down and said, we, the people of Nigeria, and we are not part of that.
And where are we?
What we ought to have done is to reject it. But we have not rejected it. It's either you agree to something from the onset or you ratify. So we are taking steps to ratify what the military gave us, whether we like it or not. Because up to now, that Constitution remains supreme. It's the ground norm. Any law that runs contrary to that Constitution becomes null and void to the extent of its inconsistency with the Constitution. Well, I'll say, oh, that Constitution was released by military, so we are making our laws, and this law is superior to the Constitution. But we have already indirectly ratified that Constitution because we are using it to operate, to conduct elections, to run our affairs as a nation.
Okay. Let's take a look at the Electoral Act Amendment Bill, for instance, that was really being hit back and forth over the Christmas and New Year holidays. Or before then, you know, you remember the scenario that played out, you know, where the president refused signing that bill into law and sending it back to the National Assembly for them to look into it again. And there was this much talk about the National Assembly coming back after the Christmas and New Year holidays, you know, with fire and brimstone, which really we didn't see. But some are saying that there seem to be these powers that seem not to give the ability to the legislature to really perform their oversight functions under the 1999 Constitution.
Now, when you have president being appointed under a particular political party, and that political party has the majority in the Senate, the House of Reps, there is always this party loyalty above the national loyalty.
Like you said earlier.
And that is exactly what is playing out.
Okay.
The party will be considering, oh, let us take it easy. We are in power. Our president is there. Otherwise, the National Assembly, they have the right to use to majority
to override the president's veto.
The president. But most of the time, they prefer to take it easy because they are considering the fact that we are in the same party. So the party loyalty is overriding the national interest.
So you mean sentiments also is a setback in the legislature or the organs of government really carrying out their functions?
Exactly.
Okay.
Otherwise, you will discover that if the legislature decides to actually play its role, checking the executive, they wouldn't even wait before taking the right steps. But because of that party loyalty and that sentiment, they are always slow in reacting.
Okay, in case you're just joining us, it's Law and You, and we are looking at the topic separations of power under the 1999 Constitution. And the very articulate and erudite legal practitioner with me is Al-Amin Alao, who is also an Islamic scholar. Now, let's look at your end, because you are a custodian of the law, and you said in the course of your expression about the president appointing, you know, the heads in the judiciary, for instance, you know, don't you also see that the judiciary is like on the begging end by virtue of appointments by the president, in that they seem not to, you know, be free or independent to do what they need to do as per administering justice. What do you think?
Thank you very much. You see, the judiciary appears to be the one that, how will say, has autonomy. They do not have the financial autonomy. Even under the military regime, military administration, where separation of power is thrown into dustbin, it does not really affect the judiciary. Because we already have the hierarchy, how we appoint our judges. So under the military regime, you see, observe that we see our courts, you have the CJ, and then appointment of judges, we have a discipline that we maintain. Now, the mere fact that the CJ is to be appointed by the president does not mean that the judiciary is not independent.
Okay.
The judiciary is to interpret the law. You make the law. The only problem we have is that sometimes you see the executive not complying with judicial pronouncements, and then you now have the difficulty now enforcing judgment against the executive. You have that difficulty.
Okay, but in such difficulties, what is expected of the judiciary in terms of putting the executive under check?
We have contempt of court. If the court order is not obeyed, no matter who you are, because the supremacy of the law has to be upheld. The law is a respecter of nobody.
And above everyone.
If you are not careful, you will find yourself behind bars if you commit contempt of the court.
But that excuses the office of the president.
When you are in office as president, as vice president, as governor, deputy
you have the immunity.
You have the immunity.
Is that not also a setback in checking the offices?
The immunity is required. If not, the president will not have the time to actually govern.
Otherwise, it will have litigations everywhere.
Will be against the president. In fact, I will also file actions against the president, even against the governor, in order for them to be able to concentrate. They have that immunity. And you can see that the immunity does not extend to the legislator. It's not also extending to the judiciary.
Okay, but does that not make the office of the president, for instance, and the governor, for instance, too powerful?
I said there must be a head. And whether we like it or not, the executive remains the head.
Okay.
And very, very powerful, very, very influential.
But isn't that what the doctrines of separation of powers, principle of checks and balances intended to check or to put under, study and
it will now depend on the particular president you have. If you have a law-abiding president, he will be checked. In fact, he will not commit excesses. He will not be a tyrannous president. But if you have a president that can influence the National Assembly to extend his tenure of office, you may have it. You discover that we have some countries in Africa who have had that done. A particular time, it was raised up and they say, oh, the president, I said the president has no fault. He was able to lobby or influence members of the National Assembly, and then they are able to extend his tenure in office. He did not force them, not at gunpoint. Now, if you look at it further, you will discover that when you're talking of lawmaking, the legislation by the National Assembly, and then any matter that is under the exclusive list is reserved.
Okay. Okay.
Then you cannot see now that even when you are talking of a particular arm of government, there is the intention to reduce, to concentrate too much power in a particular arm of government. And that is okay.
Not to bring about abuse or overuse of government power.
That explains why you now have, it is only under the exclusive list you have National Assembly legislating. Then concurrent list, National Assembly, and of course, House of Assembly of the states.
Okay.
The residual list, the State House of Assembly. Okay. But if there is a conflict between a state legislation and a legislation by the National Assembly, that of the National Assembly will prevail over that of the state. Then, going to the executive, you have the federal government, you have the state government, you still have the local government. Otherwise, we don't need governors. The president from there will be ruling Edo State. You do not need local government chairman. The governor right there will be ruling all the 18 local governments.
That's concentrating powers into one.
You can see that now we are now spreading the powers.
That seems to be like the unitary system of
presidents, you remain above, the governor remains in the state, then you have the local government chairman.
Okay. Okay.
Then, look, going to the courts, the other arm of government, the judiciary, you have the magistrate courts.
Okay.
You have the high courts. You have the Court of Appeal. You have the Supreme Court. So if a matter comes before the magistrate court and you are not satisfied with the judgment, you can go and appeal to the appellate court, now the high court.
Okay.
And if you are not satisfied with the decision of a particular judge in the high court, you can proceed on appeal, Supreme Court appeal. You can see that these are also checks.
Yeah.
So that the judge will not say, I will give judgment against you. Then I will go on appeal. And if you go appeal, also give the judgments that are not satisfied with, proceed to Supreme Court.
So that puts the judiciary in a very balanced level.
Yes.
Of
so now the
checks.
Supreme Court is the final arbiter.
Okay.
After the judgment of the Supreme Court, you can only appeal to God. Accept your fate.
Now, in the course of your expression again, I also picked one issue or idea you just raised concerning depending on the style of the president in power to really determine if that president will be autocratic or not. What's your perception about President Muhammadu Buhari and the issues that has to do with separation of power, checks and balances?
President Muhammadu Buhari was once a military president, and of course, as a military president, you issue decrees, you get things done easily as a military president. But now, as a civilian president,
the game has to change.
The game has to change.
Or is it changing?
And to some extent, you will discover that the president is rightly accused of nepotism, for instance, long-sided appointments, and there is no fairness in the appointments to positions of authority.
So which throws the issues about checks and balances into the dustbin? Of
course. And that explains why I said depends on the particular person you have on seat as the president. Okay. And then you discover that a lot of promises that the president have made, now coming to reality, those promises have not been fulfilled. And the tenure is almost elapsing. And I wouldn't say I will rate the president high. I would not give him, I can give him an average.
Okay.
Just average. I wouldn't want to call him a failure.
Thank you very much. Okay.
Because as the president alone, you also need the people to cooperate with you in order to get some things achieved.
Thank you very much for that very fair judgment. But well, it depends on his opinion.
That is my
anyway.
view.
It's your view,
yes.
And for viewers who are watching, they may have their own personal opinions also in that regard. And if we are to really give up an opportunity to score the president on that, some may not even score him up to 10% over 100. All right. So, but let's look at going forward. We have the need to amend the 1999 Constitution. Because ordinarily the provisions of the Constitution are not cast in stone, and if they are to be amended, most especially as it has to do with checks and balances, in this regard, what would be your expression or your articulation in terms of what should be done to strengthen the principles of checks and balances?
I think in order to strengthen the principles of checks and balances, the lawmakers have a lot of role to play.
Okay.
And you will agree with me, or you may not agree with me. The problem we really have is the issue of the party loyalty.
Okay.
The members of a political party that is in majority in the National Assembly wouldn't want to take a step that will appear to offend the president.
So how do you check that?
It's a very big problem.
It's a big problem.
And that explains why you need not make any broadcast before amending the Constitution as a lawmaker. It is your duty. You are to legislate for the country. You have the right to go in there and legislate. But most of the time, you see that they are always trying to listen to the president, look at the body language of the president before taking steps.
Which doesn't augur well.
It doesn't augur well.
Okay.
And that's why I commend the judiciary. Most of the time, judiciary gives its judgment without necessarily looking at the face of the president or the governor. You have seen instances where you see a sitting governor be thrown out judgments pronounced by the judiciary.
Okay.
And if you look at it again, the hierarchy of those in the judiciary, the discipline in the judiciary has made judiciary to be more disciplined, I will put it that way. If you are very rich, you can be a member of the House of Assembly or National Assembly.
Okay, thank you.
You will not be competent.
Thank you very much.
Yes.
Big thanks for taking our time to articulate this topic with us on law and you. Well, I've been having a chat with Al-Amin Alao, an Islamic scholar, and of course, a legal practitioner, and we really we've been deliberating on the topic, which is on separations of power under the 1999 Constitution. Well, I know your opinions may be different, but well, let's dig in. Let's continue to deepen democracy by looking at such concepts on democracy to ensure that we are able to have a deepened practice of it all. Well, we'll do this again same time next week, but that will be in another topic where we'll be bringing you on board up to speed on what is happening as regards the concepts of law and you. Big thanks, Al-Amin Alao.
It's a pleasure.
Time.
Thank you
again. My name is Philip Omo Yupo. Goodbye.